Hello everyone, my name is Chang Ho-chul, but you can call me Ryan. I'm a criminal defense attorney certified by the Korean Bar Association. Many foreigners in Korea panic when they hear words like detention, indictment, or trial. So today I'll explain what a detention warrant hearing is and how you can prepare if you're arrested in Korea. So if you're suspected of committing a crime, the police may want to keep you in custody because they may be concerned that you could destroy important evidence, influence other witness, or run away before the investigation or trial even begins. However, the police cannot keep you in custody for a long time without the court approval. So after arresting you, the police usually ask the prosecutor to file for a detention warrant. If the prosecutor agrees, the prosecutor files the detention warrant request with the court. Then the court decides whether to issue the detention warrant. But before making that decision, the court holds a hearing. And at this hearing, the judge meets the suspect, listens to the suspect's explanation, and reviews the arguments and evidence from both sides. And this hearing is called a detention warrant hearing or a pre-detention suspect examination. Let's start by explaining the usual timeline. So first, the investigation begins. A police investigation begins when someone files a criminal complaint or when the police discover the case through their own investigation. Second, arrest. The police may arrest the suspect or they may not. But in some cases, the police arrest the suspect with an arrest warrant. But in other cases, they arrest the suspect without a warrant if the case qualifies as an emergency arrest. So even if the police do not have an arrest warrant at the moment of arrest, that does not automatically mean that the arrest is illegal. Third, then the prosecutor applies for a detention warrant. After the arrest, the police ask the prosecutor to apply to the court for a detention warrant. If the prosecutor agrees that the suspect should remain in custody, the prosecutor must apply for the detention warrant within about 48 hours of the arrest. Fourth, finally, the detention warrant hearing. So the court then holds a detention warrant hearing within about 24 hours after the prosecutor applies for the warrant. So at the hearing, the court listens to both sides and decides whether to issue the detention warrant or deny the request. So when deciding whether to issue a detention warrant, the court considers several factors. So first, they look at probable cause. So in other words, the court considers whether there is enough reason to believe that the suspect has committed the crime. And second, whether the suspect has a fixed residence. And third, whether there is a risk that the suspect may destroy key evidence. And fourth, whether there is a risk of flight, meaning whether the suspect may run away. And finally, fifth, the court may also consider other surrounding circumstances, such as the seriousness of the offense, the risk of reoffending, and the possible harm to the victim or other important witnesses. So to avoid detention, you need to persuade the court with documents and concrete evidence that there are no legal grounds for detention. So if you did not commit the offense, you should submit materials that support your innocence or something that could at least weaken the suspicion against you. But the problem is that after arrest, the suspect is usually held at a police station, detention facility, or some sort of custody. So it becomes really difficult for the suspect to gather evidence personally. And that's why your lawyer must move quickly and work with your family or friends to collect helpful material right away. Even if you admit some of the allegations, you can still argue that detention is unnecessary. In that situation, the key argument is so the legal grounds for detention are not met and the suspect should be investigated and tried without being held in custody. In this situation, helpful materials may include statements from family members or friends showing strong community ties, proof of stable home and job, such as address records, a lease agreement, or unemployment certificates. You can also submit a concrete family support plan, including who's going to assist and supervise the suspect, and make sure that the suspect appears when required. And evidence of cooperation, like voluntarily submitting relevant materials or evidence showing that there is no intention to destroy evidence or flee. And finally, if possible, evidence of repayment efforts or settlement with the victim. In other words, you need to persuade the court that even if the suspect is ultimately found guilty, there is no real risk of flight, destruction of evidence, or harm to the victim. So here's why early response is so important. So first, there's very little time. From the moment of arrest to the detention warrant hearing, the entire process can happen in less than 2 or 3 days. And that means that there is very little time to prepare documents, organize the facts, collect favorable evidence, or if possible, try any possible settlement. Second, the detention warrant request has already been reviewed by both the police and the prosecutor. By the time the court receives the case, the police have already asked for detention and the prosecutor has already agreed to request a detention warrant. So from the judge's perspective, the case may look like it has already been screened twice. And because of that, the judge may approach the case with a certain level of skepticism. Third, once detention warrant is issued, everything becomes harder. So once the detention warrant is issued, the suspect must remain in custody during the police investigation, the prosecutor's investigation, and the trial. So it becomes much harder to gather favorable evidence from outside and respond effectively. So the key is speed. So you need to find the right lawyer as early as possible and work closely with family and friends before the hearing. So let me introduce a real detention warrant cases that I personally handled. This case involved the operation of an illegal online gaming site. So my clients were accused of operating the site and earning about 2 billion Korean won. So one of the co-offender, I'll call him A. So he had been already arrested. And however, the other co-offenders, I'll call them B and C, had fled from the police and hidden key evidence, including computers. So A was already in custody and B and C were still running away from the police. In this case, the key issue was that if a detention warrant was issued for A, then it was highly likely that the prosecutor would also request detention warrants for B and C. So preventing A's detention was the most important point in this case. B and C called us at around 5 p.m. and explained the situation. So after I understood the basic facts of the case, I immediately went to the police station to meet A. I stayed with A until about 11 p.m. while he was being questioned by the police. During the police interview, I realized that the police already established a substantial part of the case. So I concluded that if we simply denied like everything, so all of them could be detained and might face heavier sentence later. So at that point, I realized that we need to reduce the grounds for detention. And I quickly advised B and C to turn themselves in and submit the key hidden evidence. But the ironic part was that the police officers initially refused to accept my client's surrender and the hidden evidence. I think because the police knew that if B and C turned themselves in and submit the hidden evidence, the judge might decide not to issue the detention warrant for A. So I had to argue with the police, and in the end, I was able to submit the materials successfully. At the detention warrant hearing, I explained to the judge that the key evidence had already been submitted to the police, so there was no real risk of evidence destruction. And I also explained that the other co-offenders, so B and C, had voluntarily turned themselves in, so the risk of flight was very low as well. And as a result, the court denied the detention warrant request. So finally, A was allowed to go home and B and C were not arrested or detained. I mean, they still had to go through the criminal trial, of course, but because they were not in custody, they were able to prepare for trial properly. So the key lesson from this case is simple. When a detention warrant issue arises, you must act quickly. In this case, we responded immediately and we were able to reduce the risk of detention and protect the client's ability to defend themselves outside of custody. So if you're arrested or facing a detention warrant hearing, the first 48 hours are extremely important. So what you do during that time will have a major impact on whether you remain free while the case moves forward. And that's why it is really important to respond carefully and get legal advice as early as possible. So that is all for today's video. In the next video, I'll explain how to file a criminal complaint in Korea. If you need advice about criminal case in Korea, please send me an email or text message with a brief summary of your case. Then we can schedule a meeting and discuss the next step. Thank you for watching.